Yes, sir. May it please the court, counsel. Brett Clark on behalf of Bob O'Toole. May I do the usual 5-minute in rebuttal, and if I finish early, then I can reserve the rest of my time. Bob's case can best be described in shorthand as by the adage, no good deed goes unpunished. Here is a man who invited Iris BEAUGRAND to come live in his house along with her 4 children. And lo and behold, he's now lost that house, as well as the house that he's currently living in, both his homestead. How did we get to this point? What happened was there were some deeds signed at the insistence of Ms. BEAUGRAND, whereby Bob deeded or placed her name on the title to his property. And for some reason, that the same thing didn't happen to the property owned by Ms. BEAUGRAND, even though Bob moved into her house and, according to his testimony, paid the lion's share of both sides of the mortgage payments for that house. They had an agreement whereby Bob would refinance his house so that he would reduce his mortgage payments and thereby move into her house, rent out the property that they were living in, and he was obligated to pay 1/2 of the mortgage payments. But as time developed, according to his testimony, he paid more than his half of that property. And so the argument was made in the court below by her that this case is resolved by simply looking at form over substance. You look at the deed. If you're able to induce your partner to sign over property into your name, then ipso facto, in essence, you are entitled to partition of that land, and you take 1/2 of the equity in the property. However, that's not what the law is. The brief, I think, adequately explains why this is so, why our position is what it is. And according to my notes here, I have like 7 different points, no, 9, concerning the brief, and it's a long brief. There's a lot of points that are raised in part of this case. My point here today is to try to zero in on the salient points that are raised in the time that we have.
Remind me, at the end of the day, they had the one house that they built, and then they had 2 rental properties.
Correct.
Okay.
That is essentially true.
Okay. And the 2 rental properties were titled in both names?
The first property, Bayshore, we'll refer to that as the Bayshore property, was titled in Bob's name, but when they refinanced it, according to the lender, according to Ms. BEAUGRAND, the lender required that her name be inserted onto the title.
Okay.
So thereby she became, as far as the deed was concerned, a joint tenant in the property. However, when you go behind the deed and you look at the facts, you find that the sole purpose for having her name on that title was to facilitate the loan. And so therefore, in the cases that we have cited, the court does not look to the deed on its face without inquiring further. It was clearly a resulting trust. The property was held in a resulting trust. And I would refer the court to the Waldeck case. I think that's one of 2 principal cases, although we cite quite a few. That one is instructive because in that case, the court looked to the conduct of the parties and their agreement and found that even though the deed was a joint tenant, created a joint tenancy, presumably, as the judge delved further into it, he found that that was not the nature of their agreement because the lawyer...
Refresh us on this. Which one are you talking about, the Charlotte County or the Sarasota County?
We're still on the, well, I guess the principle applies to both, but we're still talking about the Sarasota County case, the Bayshore property.
That's the one that was his sole name and the bank made him.
Yes, sir. Yes, sir. And the Waldeck case instructs that the court looks to the substance, not the form of the deed. And in that case, the court found, even though the deed on its face reflected a joint tenancy, the truth was, it was, in essence, a tenant in common, because the lawyer involved did not provide consideration. He didn't buy into one half of that property. And so therefore, the court looked to the substance of it and found basically tenant in common. In our case, by contrast, the court should, in our view, look at this as a resulting trust. The property was held by way of a trust, a resulting trust by two people, even though the deed states that they were joint tenants with rights of survivorship. The facts are undisputed. In essence, Ms. BEAUGRAND herself testified that that was the
And the
case.
effect of it being a resulting trust is they would be unable to request partition of it?
I would say yes. I would say yes, because she doesn't have title in the normal sense. She's not a joint tenant. She's holding it as trustee, in essence.
For whom?
For Bob. For Bob and his children. There was some...
Based on his testimony, correct?
Well, she did not dispute that. She hasn't disputed that.
I actually read in the transcript where she did.
Where she...
Where she said that there was no estate planning aspect of
Yeah,
this at all.
yeah, that is true.
And I mean, you know, maybe she's lying, maybe she's not, but there was testimony that she flatly contradicted that assertion.
She did, but yet when I, under cross-examination, if you recall, I'm asking her, well, why was it put in rights of survivorship, and what was the plan? And then she started to equivocate on that at that point.
That's a fact call for the trial judge to make, correct?
If it's relevant, because the point being that she herself agreed to what was relevant and what is important in the case, which is that they had an agreement that they would refinance the property, that the property was placed in her name solely to facilitate the loan. She did not buy into it. She did not have an equity position in
And again, we're talking
property.
about the Sarasota property.
Yes, sir. I haven't gotten to
For right
the other
now.
one just yet. So I would beg to, I agree with, she says, well, there was no estate planning, but yet when you start questioning her about it, you see that that was the purpose that Bob put it in her name with rights of survivorship. Otherwise, why would he do that? And it's partly his intent, I would say, on that issue. And again, it's not really relevant to the point being that was this a resulting trust or not? And by her own testimony, she agreed that this was the purpose of placing it in her name. She did not buy into the property. It was held because the bank required it to be in her name. Okay. We've gone on at length in our brief about partition, the proper procedure. Our view is that the court, according to the cases that we cite, there's a procedure that you must follow, and the first step being, what is the interest of the person who is asking for partition? And that gets to your point, Judge Lucas, that the court inquires, what is your interest? Because you're asking that the property be partitioned. The court has to calculate what is your percentage interest in this property, and therefore it goes forward. If it finds a partition is proper, you have to go through the calculations to find out what is your percentage interest in it, how much money did you put into it, and then you go through an accounting. That's what partition is. How can one do that if...
That ties into your arguments. That point actually ties into a few arguments, it seems like. The partition, the accounting.
Right.
My question, though, is that in reading through this record that we have, I have two people testifying, as best as they can recall, about what they thought they were doing in these intermingled financial transactions. I don't see kind of a running ledger. We don't have a CPA. We don't have a bookkeeper. We don't have anyone that actually, for the benefit of the trial court, lays out, hey, here's to the dollar, here is what she put into the pot. To the dollar, here's what he put into the pot. We can do some offsets based upon, maybe what she brought to the table with the mother's loan, et cetera. We don't have that. We have just basically everyone, these two parties each recalling, yeah, I put in this, no, I put in that. You're asking, it seems to me, you're asking for a level of precision on the part of the trial court that it just wasn't given.
No, I would beg to differ in the sense that, and your point is well taken, that they were a mess with their accounting. Their bookkeeping was not up to snuff, and that is why we stated, we asked for an accounting so that those things can be adjudicated. And at that point, at the point of the trial, we hadn't had a court ruling on whether or not an accounting should be had, number one, and number two, what are we accounting for? Because we first have to establish what was the agreement between the parties, and then have the court say, yes, that is, that point has to be litigated and has to be resolved.
Well, did anybody ask, hey, Judge, here's what we want. We want a preliminary ruling, or we want to bifurcate this. First, determine entitlement to an accounting. Discrete question. Are the parties entitled to an accounting? Judge says, no, we're going to do it all at once.
Yes, sir, I did.
Okay.
At the trial, I did say that. And I even told her, the judge, pardon me, said, you're off the hook, Judge, because right now we're just going to determine the lay of the land, so to speak. What are the respective rights of the party? What were their agreement? What is their percentage interests in the properties, if any? And then once we establish that, then we can go to the time and expense of calculating what the accounting should be, because we can't ask the CPA beforehand, before we get a ruling on that. And that seems reasonable to me as an officer of the court, mindful of judicial resources and attorney's fees. We need to determine what the accountant is supposed to be counting before we have a trial. And then the trial would have been a lot longer, and the judge would be there listening to testimony for going through bank records and other things for days on end. And so I think our position was reasonable in that respect. We should have had a ruling on what beans we're counting before we start counting them. Okay, so the other case that I think is important is the Dietrich case. And that case establishes the basic rule under which the courts heretofore have determined rights of unmarried couples when they find themselves in this entanglement. We're still talking about the Sarasota properties, but that case is a good poll star sort of, because it establishes two concepts. One is that, yes, the courts will uphold the contract between two parties, even though they're unmarried. And number two, you can't ask for partition in a circumstance like that unless you are entitled to the property in question. This relates to the other property, the Pinto Ranch property, which is also in Sarasota, because they had an agreement, both parties agreed. It was undisputed that they had an agreement, and it makes some economic sense on its face that Bob would refinance his property, rent it out, and then that way he had no financial obligations for that, and that freed him up to move into the Pinto Ranch property and start making one half of the payments. And this is, both parties testified and agreed that that was their agreement. And so what happened afterwards, it turned out maybe it didn't make so much good economic sense, because if you, in the transcript, you'll see Bob was led to believe that mortgage payments would be $2,000 a month. And then he was surprised to find out it was $3,000. And also as things developed, he ended up not paying one half, he started ending up paying both halves. And so our position is that he's entitled to a credit for the amount he overpaid for that property. And that was pursuant to their agreement, and it's also what is fair, because his name was not put on title to that property. Yet,
Mr. Clark, excuse me, you're into your rebuttal time, but.
I am?
But use your time as you wish.
Okay, my time goes so fast. I think what I'd like to do is if the court has any questions, in particular, there's a lot of material in this brief. It's very long. I apologize in advance. But if there's no other further questions, I'm going to reserve the minute that I maybe have left.
Thank you, Mr. Clark. We'll give you have 5 minutes on rebuttal.
Thank you.
Mr. Williams?
May it please the court, Steele Williams, on behalf of Iris BEAUGRAND, the appellee. Iris is here today. This case is about, or started when Iris filed a partition complaint for one piece of property. I call it the Bayshore property in my brief, that was jointly titled between the parties. In response to that partition of that one property in Sarasota, the appellant, Mr. O'Toole, filed an extensive counterclaim dealing with 4 properties and personal property that were gathered during their relationship. And in each of those counterclaims, he was seeking a declaratory decree as to what the rights were in the agreement of the parties, resulting in constructive trust, a reformation, and a special equity as to what he had contributed to each of those properties. Now, the personal property issues were resolved at trial, so those aren't on appeal, and nobody's disputing that. And there was one property, a commercial property in Charlotte County, that dealt with Ms. BEAUGRAND's parents, that was also agreed to and resolved at trial. So now we're only dealing with 3 properties that are the issue of this appeal. As to the property, the Bayshore property, which was the subject of the complaint by my client at the trial level in Sarasota, that's a Sarasota property. Again, there was a counterclaim asserted by Mr. O'Toole, the appellant. Okay, you have to determine what the agreement was as to this property, and I'm entitled to a special equity in regards to this property because it initially was mine. Well, the trial court denied the special equity and found that the parties owned it jointly. And the evidence of that is based on the testimony of Mr. O'Toole himself. Mr. O'Toole was on his second foreclosure as to this Bayshore property. 2007, he didn't have credit. That's what the evidence was. There's a reason why he didn't have credit is because he hadn't filed taxes in 20 years, and there's no way he was going to be able to get financing of this property. To avoid foreclosure of the property, his girlfriend uses her credit to refinance the property out of foreclosure. Now, the evidence at the time of that foreclosure was that the value of the property was almost nothing to the extent that there was equity in the property. There was a 2008 property report put into evidence, stipulated to by the parties, that the value at that time in 2008 was $219,000. The mortgage amount that was refinanced by the use of my client's credit was $226,000. So further, and that was only evidence as to if there was any equity in the property at the time of the foreclosure, okay, or at the time of the refinancing of the foreclosure. Further, there was no evidence, not a scintilla of evidence, or any proof of evidence that there was equity in the property by Mr. O'Toole, the appellant, or that there was $100,000 in value there that was usurped or whatever. So the evidence correctly was decided by the trial court that, you know what, if this property doesn't get refinanced, it would be foreclosed, and that's why you guys ultimately ended up owning it jointly. And in fact, that was what the testimony was by both parties. They were going to own it jointly and use the rents from that property to pay the mortgage, and that's what they did up until the time of the split between the parties in August of 2016. Mr. O'Toole took exclusive control of the property. My client essentially was precluded from anything with regards to the property. That's why the partition action was absolutely necessitated. The argument that my client should forever hold in resulting trust this property that she's forever connected to as a result of the use of her credit is simply not correct, and it's specious.
Well, let me
Yes, sir.
ask a question based on your friend's argument, which is that the judgment before us appears to just simply say these properties are held as tenants in common, if I remember correctly. For purposes of the relief she ultimately wanted, which was partition, how from the judgment are we to ascertain who gets what of these properties when they're partitioned and sold?
The judgment on its face is a form judgment, and the judge ruled that the parties own it jointly, undivided interest, and that upon a sale of the property, that the proceeds will be split equitably once costs are paid. So the judgment on its face essentially rules that the parties own it jointly. And from an equitable consideration, that if there's any leftover of a forced sale, then those proceeds should be split jointly.
Equitably?
Equitably split.
Right. What is that? What is, and that's my point. What, is that 60-40, 50-50, 70-30? What is that here?
Well,
Because part of the relief that both sides sought was a true-up, was an accounting.
Your Honor, if I may correct the record in that point, my client sought an accounting in her initial petition for partition because of the necessities of the landscape that was occurring. My client was excluded from the property, didn't know who was renting it, didn't know if rents were being occurring. So we were seeking an accounting from August 2016 forward. By the time we got to trial, we realized that the rents that had been accumulated from the property had somewhat been paid, the first mortgage, had not paid the second mortgage, still hasn't paid the second mortgage. My client's credit's been ruined as a result of that. So I think the accounting request by my client was seeking what had happened to the property from August 2016 forward, not let's go back prior to the relationship split up and determine from the record who paid what. And nobody requested that.
Nobody requested to determine how the property should be partitioned and how, if there's any equity in it, the proceeds should be split? Nobody asked that question of the trial court?
No. I think my client said, we're trying to race to the finish line here just to get done with this case. And if you'll notice the pleadings, we didn't seek a motion to dismiss or anything like that. We said, okay, that's your counterclaim, let's set it for trial. And we try to set it for as quickly as possible. But certainly at the trial level, based on what we've determined by the evidence, the parties get to split the equity in the property, and that's what the judgment was.
How did they split it?
50-50. That's what the judgment said.
Okay, well that's what I'm waiting to hear. Is
Okay.
Your position is that if there's, according to the judgment, I can read the judgment and I can ascertain that when this property sells, any equity that's left over, any resulting monies that come from it, the parties are split at 50-50. That's the determination the court made.
Yes. Okay, sir. Okay. There's the other property of the parties, or the other property of the counterclaim, the Pinto property. This was a property that Ms. BEAUGRAND bought in her individual name, that she got the financing solely for the construction of this property. Okay? 5-6 weeks prior to the trial of this cause at the Sarasota courthouse, trial court, we asked Mr. O'Toole, okay, what are your claims as to the Pinto property? What's the basis of the claim? I don't have any claims. At trial, I asked him that. At trial, 7 weeks later, he says, well, no, I didn't understand what you meant by claims. And I said, well, okay. So he took the position at the trial court, I paid all the mortgages on the Pinto property. My client took the counter position and testimony and said, well, wait a second. You didn't pay all the mortgage on the Pinto property. I paid most of it, so there was a dispute, in fact, as to the testimony. There wasn't documents from Mr. O'Toole whatsoever as to what he had paid or the like. There were documents submitted by my client when pressed on rebuttal evidence of payments she had made. That was and the court further, in looking at the equities as to the Pinto property, there was no agreement of the parties for Mr. O'Toole to be an owner of the Pinto property, to be on the financing of the Pinto property, or to somehow he's building equity or he's building some sort of value in the Pinto property by him making whatever payments he made. There was no, that's what his position was at trial, but my client's position was the counterfactual position. Further, in regards to the Pinto property, the evidence is that as of the time of trial, property's $100,000 upside down. We're not here talking
The
about...
Pinto property is not involved in the judgment, though, is it?
The Pinto property is not involved in the judgment. Yes, sir, correct, Your Honor. It is involved in the sense that the counterclaim for a special equity and a resulting trust and a declaratory decree as to what the agreement was as to the property was denied in its entirety. So while it's not specifically listed in the judgment, it is denied as a part of the counterclaim that was adjudicated at the trial level. Okay,
Is the
did I
Pinto
answer your
property
question?
an issue that we need to do anything with?
I didn't hear that. I
Is
apologize.
the Pinto property anything we need to consider?
It's my understanding, based on the appeal and the briefs that have been filed in this case, is that the appellant is still seeking that he's entitled to some sort of value or recognition of an agreement, that he's entitled to something with regards to the Pinto property, and we're of the position that the trial court found against him specifically on that and denied his counterclaim in that regard.
Correct, Mr. Clark?
Sort of. I'll address it on rebuttal.
Okay.
If you so wish.
Again, based on the facts and the evidence presented as to the Pinto property, the trial court correctly denied the counterclaim for special equity, declaratory decree, and all the various remedies and relief sought. Now, as to the Charlotte property, at the same time the Sarasota case was going forward, there was a Charlotte case that had been filed, okay, regarding the jointly titled rental property of the parties down in Charlotte County. The parties understood or recognized that, well, wait a second, there's also a counterclaim with regards to this Charlotte County property, seeking a declaratory decree as to what the agreement was between the parties, the resulting trust, and all these various other remedies in the Sarasota case. So the Sarasota court certainly had in personam jurisdiction over the parties to determine what that agreement was with regards to the Charlotte property. The parties recognized, now wait a second, we're going to have res judicata certainly, because the Sarasota court is going to get to the finish line on the adjudication of these factual issues as to what the agreements were between the parties, certainly as to the Charlotte case, and certainly collateral issue, collateral estoppel on any issues pertaining to that Charlotte case. Why don't we agree, make an agreement, a stipulation that, well, whatever the agreement is with regards to the Charlotte property and the agreement of the Charlotte property between the parties by the Sarasota court, we will agree that will be binding on the Charlotte County court, but not in the sense that we're going to usurp the jurisdiction of the Charlotte County court. We're not going to shut down the Charlotte County case. We're still going to keep that open. We're going to tell the Charlotte County trial judge, for economies of the parties and for the judiciary, we all recognize that the factual disputes between the parties are going to ultimately be first decided by the Sarasota court. It only makes sense to not litigate attorney's fees and additional costs and expenses and litigate those same issues in Charlotte and say, hey, this is what the court said, this is what Mr. O'Toole said. I mean, that doesn't make sense. So the parties did stipulate that the Sarasota court could adjudicate all of the issues pertaining to that Charlotte County property. This is, that happens a lot where it's not a situation where my client is initially seeking partition of the Charlotte County property in Sarasota, where that would be an improper usurpation of jurisdiction. That's not what we have here. We have an agreement of the parties similar to an arbitration agreement or something like that, where any fact issues pertaining to whatever their agreement was as to that agreement pertaining to that Charlotte County property will then be reported to the Charlotte County court, which is still open to this day because this matter has not been resolved. Before I conclude, are there any questions of the panel? Just in conclusion, there's 3 properties at issue. There was a lot of facts and testimony, certainly by both parties, as to those issues, as to what their agreement was, or as to whether Mr. O'Toole is entitled to special equity or not. And those fact issues were decided by the Sarasota trial court, and those fact determinations should be affirmed by this court. Thank you, sirs.
Thank you, Mr. Williams. Mr. Clark?
Yes, sir. I didn't want to take up some of his time in answer to that question. We mentioned the Dietrich case because the reason it is so important is for those twin reasons.
My question is the Pinto property subsumed in paragraph 6 of the final judgment related to the counterclaims of Mr. O'Toole?
Yes, in the sense that we requested reimbursement, but we can't assert title to it, and we can't assert partition because under the Dietrich case, that's not a remedy that is available. In that case, the court said, however, that the woman in that case, it was an unmarried couple, that she had invested money in that property, and she couldn't get partition because she didn't have title, but she was entitled to reimbursement of the money. It's really a contract theory or a quasi-contract in quantum meruit, however you'd like to phrase it, but that is what the relief that we're seeking. We're seeking reimbursement for the expenses that we paid over and above what we were obligated to.
Flipping gears real quick, just to the properties that a partition sale was ordered, I mean, arguably, your issue might still be open, right? I mean, in terms of who gets what, if to the extent there's any equity. Put it this way, if these sales don't generate any value, if there's nothing left over after the debts are paid, then, you know, it is what it is. But if there's some pot of money left open there, paragraph 7 of the judgment, the court reserves jurisdiction to enforce the judgment. All it said was that the proceeds should be split equitably. If you disagree with your friend that 50-50 is an appropriate split, bring it to the trial judge.
I do, however, the judgment, I'm pretty sure it says it will be equally divided, and that was the problem I had with it, because in the pleadings, it asked that it be equitably divided, but I believe in the judgment it says equally divided, so that means 50-50. It doesn't mean, and there's no, can I now go back to the trial court and ask for an accounting?
You're right. It is, my eyes are getting bad. It
so
does
I'm
say
stuck.
equally, not equitably.
I'm stuck with that, and also the equity line. There's a dispute as to this equity line, which was Iris BEAUGRAND's equity line that she took out. Are we to sell the property and liquidate her equity line that she used for her purposes? There's a dispute in the record. She says, well, no, I drew on that equity line to pay Bob's child support, and then she started making payments on it, and there was the evidence contradicted that claim, but that's why we have an accounting. She should be entitled to come forward with evidence proving that that there was no money taken out of that equity line for her benefit, because as it stands right now, we're gonna liquidate the property, we're gonna settle on the courthouse debts, we're gonna pay off her equity line, we're gonna pay off the first mortgage, and then we're gonna split things 50-50 if there is anything left over. I think in essence, what we're asking for here is an accounting. We object to having the house sold, and we've given the reasons why. But if that is going to happen, look at all of these cases, and you have judgments entered by able trial judges, not to impugn the trial judge here, but they go into details. They write findings. They make findings of fact and conclusions of law, something that this court can benefit from to understand what her reasoning, what the reasoning was in the trial court, and frankly, the parties, because right now what we have, what looks like an arbitrary ruling, like a general verdict entered by a judge, without any explanation and no idea on our part what is the reasoning behind this ruling. On the subject matter portion of the case that I neglected to mention it in my opening, I think that issue is more or less conceded. The trial court here did not have subject matter jurisdiction. And the court heard a case, Judge Lucas, you weren't on the panel for the earlier case, Gaffney, I believe it was, and there the appellant was making the argument about subject matter jurisdiction. But I would commend the court to the article written by Judge Stevens that is cited in our reply brief that does a very good overview, gives background information about the difference between in personam jurisdiction, subject matter jurisdiction, and what the judge in that article refers to as procedural jurisdiction. And that comes into play somewhat in this case because our pleadings were a mess. The plaintiff did not file a pleading asking for a partition of the Charlotte case. And so right there we're on shaky ground. In the trial court, I did a mea culpa. I said I did stipulate, because his counsel, he's right when he says it makes sense to try everything in one case, but the law does not allow it.
Well, what you all could have done is tried all the factual issues, have the facts determined, get it right up to the finish line. But the paragraph about ordering sale of property outside the Sarasota court's jurisdiction might have been problematic.
No, I would say based on what cause of action, because the plaintiff would have to assert a cause of action where facts are determined and a judgment is made as to some sort of cause of action. It can't be partition.
I think there was a deck action, wasn't there?
No, they did not. They did not ask for a deck action. In fact, we did. We asked for a deck action, and it was rejected out of hand. The court said no. I'm not going to entertain a deck action. So that leaves the court below with no cause of action upon which it can make findings of fact that would be binding on the Charlotte County Court. So.
Mr. Clark, you're going to have to wrap it up, please.
Okay. Well, that's all I have. I hope I was able to answer all of the questions in this fascinating and interesting and important case, and it's certainly important to us.
Thank you, Mr. Clark.
Thank you.
Thank you both.